Our statutes say that courts shall not accept a waiver unless it's intelligently, voluntarily, and understandingly made. That they have to look at the age, the intelligence, the education, the emotional stability, the complexity of the proceedings. Those are all parts of our statute now. So tell me that it's not necessary. How do you ascertain that the waiver has been given intelligently? And again, somebody will stand up and say, oh, well, they don't have the right to waive because they have the attorney before they have the right to waive. The attorney is there to explain to the child what in the world is going on. Then there can be waiver. Again, NACO was the only opposition, and with this amendment that is coming on, they removed their opposition, and you've received a letter to that. I hope, my friends, that we don't need to keep discussing this. I think we can vote and move on. If you want to spend the 6 hours, you may spend the 6 hours, but I have enough for cloture. And if any of you forgot whether or not you gave me cloture on this, you're welcome to come see my list, which has been handed to the Speaker. And so I don't intend to talk further unless there are continuous efforts to incorrectly create a record. Thank you, Mr. President.
Thank you, Senator Pansy Brooks. As the clerk stated, there are amendments from the Judiciary Committee. Senator Ebke, you're welcome to open on your committee amendment.
Thank you, Mr. Speaker. AM 145 to LB 158 makes 2 changes to the bill. First, it addresses concerns about the appointment of counsel for juveniles who participate in a pretrial diversion program by clarifying that under such circumstances, counsel need not be appointed. And second, it adds a requirement that a judge inform a juvenile of his or her right to rescind a previously given waiver of the right to counsel at all hearings following such waiver. LB 158, as amended by AM 145, advanced from the Judiciary Committee on a vote of 7-0 with 1 abstaining or not present. On behalf of the committee, I ask for your green vote on AM 145 to LB 158.
Thank you, Senator Ebke. Mr. Clerk.
Well, Mr. President, just if I might clean up some carryover provisions or issues from last year. Senator Hughes, I had a motion from you, Senator, to bracket the bill until June 2nd of 2017. Obviously, that's to go away. Thank you. Senator Chambers, I have a motion from you to bracket the bill until April 18 of 2018. Withdraw. He wants to withdraw. Mr. President, I have an additional priority motion, but if I might, Senator Pansy Brooks, I understand you wish to withdraw AM 996. That was the amendment from last year. Thank you. Senator Pansy Brooks, I also understand you wish to withdraw AM 1772. Thank you, Senator. Senator Pansy Brooks does have an amendment to the committee amendments, Mr. President, but I do have a priority bill. Senator Groney would move to bracket the bill until April 18 of 2018.
Senator Groney, you're welcome to open on your bracket motion.
Thank you, Mr. Speaker. I stand again, as I have twice before, against LB 158. It is not needed. It is not wanted in rural Nebraska. No one has ever came forward to me and said, no child, no, let me rephrase that, no juvenile between the ages of 14 and 18 has told me they were not treated well in the courts. Senator Pansy Brooks continues to say children, children. Let me read to you the statutes that are already in place. I'll skip the counties with populations of 150 or more. In counties with a population of 150,000, any minor 13 years of age or younger charged in a juvenile court with a law violation or statute offense is automatically given a lawyer. See Nebraska Revenue Statute 43, revised statute, not revenue, 43-3102, 2017. B, any minor placed in detention is automatically given an attorney. See Nebraska Revised Statute 43-3102, 2017, and 43-250, 2017. I don't remember voting on those. Any minor where an out-of-home replacement is sought, they are given an attorney. See Nebraska Revised Statute 433102, 2017. Seems like a lot of this was in that one bill we already passed. D, any minor where a request is made to transfer the matter from the juvenile court to adult court. See Nebraska Revised Statute 433102, 2017. Is given a lawyer. When a probation violation is filed seeking out-of-home placement or detention, I believe I just said that. When a minor requests an attorney, 43272, 2017. When a parent or guardian requests an attorney, Nebraska Statute 43272. When a parent or guardian cannot be located, Nebraska Statute 43272. Attorney fees are paid by the county upon approval of the court. We're talking about 14-year-olds to 18. The last day they're 17. That's who we are talking about here. We're not talking about small children. Everybody else under the age 14 gets an attorney. Waiver of counsel. It's a fundamental right.